Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 246 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where together with my colleagues we provide advice and assistance to both employers and employees on all aspects of employment law and HR. Our flagship service is our HR Harbour membership, which for a fixed monthly fee provides businesses and organisations with the confidence and reassurance to know that they have dedicated employment law and HR advice and support on the end of the phone, on an email, and that we will keep you updated on all aspects of employment law to ensure that not only are you meeting the legal requirements, but that you are being the best employer that you can possibly be. Now, if you were to join our HR Harbour membership service in May of 2025, when this podcast is going out, it would of course provide you with coverage up until May of next year. So it's a 12-month minimum contract. So even if you stuck around with us for 12 months only, you would have assurance that all of your documentation and implementation is all up to speed in regards to the forthcoming changes to employment law. As you may know, there are significant changes coming potentially at the end of this year, but most definitely in 2026. So to ensure that you are covered, you don't have to stress or worry about what you need to do, why not get in touch and have a no obligation quote from us and see how we can help you and give you that peace of mind. You can contact me by email. It's alison@realemploymentadvice.co.uk. So without further ado, I'm going to get into this week's featured content. Now this is episode 5 of a mini-series on TUPE, the Transfer of Undertakings Regulations. And this is the last episode in that mini-series. For those of you who have listened previously, you'll know that we've covered off all aspects of TUPE in the last 4 episodes, from how TUPE applies, what it is, through to employee rights as a result of the Transfer of Undertaking Regulations. And today I'm just going to round off the mini-series by dealing with some of the frequently asked questions or issues that arise in relation to TUPE. So the first question that we're always asked by employers who take on employees after a TUPE transfer is, can we change the employee's terms so that they are the same as our own? Now, the simple answer to that is, if the changes you are intending to make are related to the transfer, then no. Any changes that you make to employment terms that are related to the transfer would be void. So you can't just make changes to their employment contracts so that they mirror your own existing employees. Now, what this can mean for some employers is that you are running 2 sets of employment contracts. And if you're the type of organisation that takes on contracts or often has TUPE processes applying, then you could have a number of different terms and conditions running alongside each other in relation to your employees. There is a very limited scope in which you can make changes to employment contracts. Now that leads me nicely on to question number 2, which is, when can we make changes to employee contracts? Well, you can make a change to an employee contract, firstly, if the contract allows for that change. So regardless of whether it's related to the TUPE transfer or not, if the employment contract allows for that change to take place, then you are able to make that change. The second time in which you're able to make changes is where the change doesn't relate to the transfer. So it's wholly unrelated or because of some other consequence. So for example, one of the things I said in a previous episode that often arises is where there's been a re-tendering for a contract for the provision of services, and the client who's tendering out for that makes changes to what they actually require, therefore making changes to the contract between the transferor and the client. So in those circumstances, if you need to then make changes to employee terms and conditions in order to fulfill the client contract requirements, then that wouldn't be related to the transfer, but rather the reason for the change is because of the change that is required by the client, and of course which is outside of your control. And then the third way in which you can make a change under the TUPE regulations is if you have an economic, technical or organisational reason that entails a change in the workforce, then you would be permitted under one of these exceptions to make that change. Now, the circumstances in which you may need to make an economic change could be where, again, the value of the contract has changed or the provision of services is altered in some way, meaning that economically you can no longer continue with those terms. So it's important, if you are taking on a new contract which would involve the transfer of employees into your employment, that you do your due diligence to fully understand what the pre-transfer terms are and to ensure that you can honour those post-transfer. Because the last thing you want to do is to take over a contract, for example, take on employees and then realise that actually the terms and conditions that you are left with from those employees you've inherited actually make the whole thing unviable and not worthwhile. And then there's no way out of it. So it's important to keep that in mind if you are involved in TUPE transfers, particularly if you're involved on a regular basis. The next question again is linked to a change in the contract terms, which is what happens if it's been a couple of years since the transfer? Can we change the terms of that employee's contract? Well, again, no matter how much time has passed, if the reason for the change is related to the transfer, then it would still be void. So even if it's, several years later and all you want to do is to align the employee's contract terms with your existing terms, that would be in relation to the transfer and therefore would be void. So there isn't any safe period of time in which you can make those changes. Now, of course, a long passage of time would make it more difficult to link the change to the TUPE transfer, but it's not unheard of and it's important to keep that in mind. The fourth question that often arises is what happens to employee holiday entitlement when they transfer? Well, an employee transfers their holiday entitlement to your employment and it is not prorated for the period of time in which they were with the previous employer and the period of time with which they are with you. So if they come to you partway through the holiday year and they haven't taken any annual leave in that holiday year, then you have to honour that entitlement to holiday for the full annual leave entitlement. Now again, what often happens is if you are, for example, taking over employees of your client or customer or taking over a service or bringing that service in-house, then you can often make an arrangement with the outgoing employer where you are paid for a proportion of that holiday entitlement so that you are compensated for that. Again, that's part of the due diligence and contractual process that you need to go through. It's also important that you ensure you obtain those holiday records so you know exactly what an employee has and hasn't taken in that annual leave year. But their entitlement carries on, you inherit it just the same way as their previous employer. The next question is, what if there is a break between one contractor and another in an outsourcing contract? Well, if there is a break between the contracts, but the service is continuing and remains the same, then TUPE would apply. If there is a significant break in time between the two service providers, then it could be arguable that TUPE doesn't apply, but it would need to be a significant amount of time in order for that to be the case. And of course, if there is going to be a large break between the two contracts, then it's likely there will be no work anyway, and there'll be a potential redundancy situation which the outgoing contractor would have to deal with. So a short break or a short insignificant break would not mean that TUPE doesn't apply. But if it's a very long break between the two contracts, then it's questionable that TUPE would apply. Question number 6. What if the client decides that they no longer want the service we provide, they do not appoint a new provider, and they do not bring the work in-house? So essentially what's happening is the service that you provide is no longer there. Now in these circumstances, what it would mean is that there is a redundancy situation. So your contract with the client comes to an end, there is no further contract awarded to another service provider, and the client isn't bringing that work in-house, so they're not doing it themselves. In that situation, then you would need to go through a redundancy process with your employees who are assigned to that contract and follow the normal consultation processes and look to see if you have alternative vacancies for them. And if there are no alternative vacancies, then you would need to make them redundant and therefore pay statutory redundancy pay. Again, it's something to keep in mind when you are engaged in fixed-term contracts with clients. If particularly you are taking on a large number of employees to fulfill that contract with that client and it's for a defined period of time, you need to keep that in mind and factor into your costs in relation to that, the potential cost for redundancy if the contract comes to an end and is not re-awarded or continued. Question number 7 is, what if TUPE does not apply to a particular employee, but the transferor and the transferee agree for them to transfer? So in a situation in which there is an arrangement between both parties for the employee to transfer, and it's not a circumstance in which TUPE would apply to them, but everybody's in agreement, then the employee would transfer and their terms and conditions would continue as normal. There may be protection in place for that employee in relation to TUPE, even if they are not directly affected by the transfer itself. The fact that they have transferred over means that they would be affected, and therefore my view is that you should treat them in the same way that you would treat an ordinary employee who's transferring over. But again, of course, you need everybody's consent in relation to this, and it does happen on occasions, particularly where there is a business sale or the transfer of a business on a sale circumstance where the employees involved are integral to the business. There can be an arrangement where they transfer regardless of TUPE. The next question that often arises is in relation to retaining employees that TUPE applies to. So if TUPE applies to a particular employee, so they're assigned to a particular area of the business or a service that is then transferring, but you decide that you would rather keep that employee and you've got work for them elsewhere, how does it work? Well, the main thing to do is to talk to that employee and get their agreement to remain with you, recognising that they could transfer if they wanted to. And if they agree that they want to remain employed with you, then you would just make the arrangements in terms of changes to their contract terms to ensure that they are covered by the new role and everything is agreed in writing. In those circumstances, you can then omit that employee from the employee liability information sheet that you provide to the incoming employer. So if that employee has already agreed to be redeployed elsewhere in your business and they're not going to transfer, there's no need to provide their details. Now, of course, it may be that you've included them within the TUPE information that you've provided, and in the situation in which they decide to stay with you, then you can notify the incoming employer that that employee will no longer transfer. The same goes if you have an employee who decides that they no longer want to continue to work there and they don't want to transfer. In those circumstances, you can, of course, notify the incoming employer that they won't be transferring or that they've given you an indication that they don't intend to transfer. And then the final frequently asked question is in relation to employees who are reluctant to transfer. So I mentioned just now, those employees who decide that they don't want to transfer for whatever reason, it is entirely their decision as to whether they want to transfer or not. And if they choose not to, and you don't have a space for them, or you don't wish to redeploy them in your organisation, then their employment will come to an end on the date in which the transfer takes place. There will be no entitlement to redundancy pay, no entitlement to notice or anything else. Their employment will just come to an end. And there is no obligation on you to find them alternative work because, of course, they have the right to alternative work under the TUPE if they transferred to the new employer. Now, of course, if they are deciding not to transfer because they object to some of the proposed changes that the new employer is making or intends to make, and they have been dealt with as part of the consultation process, so they know about them and they've decided actually I'm going to object to the transfer because of that, then it may be that they have a basis of claim in relation to those proposed changes, but it will depend on the circumstances. But if they don't have any objection for a legitimate reason due to the incoming employer's conduct or intended conduct, then their employment would come to an end and they wouldn't have any basis for claim against either party. So there we have it. Those are the frequently asked questions, or some of the frequently asked questions about TUPE and how it works in practice. Hopefully we've covered off most of the things that you need to know from a general basis in relation to TUPE in the last 5 episodes. But of course, if you have any other questions or any topics or anything that you want covered in a future episode, whether it be TUPE related or not, please don't hesitate to get in touch. You can email me, it's alison@realemploymentlawsadvice.co.uk. Finally, I just want to remind employers that if you haven't already taken steps to deal with your duty to prevent sexual harassment that came in October of last year, you need to ensure that you are taking some proactive steps to ensure compliance with the new law. If you need any further information on this, or if you'd like to arrange training for your managers and staff, again, this is something that we can help you with. You can find all the details on our website, realemploymentlawsadvice.co.uk. Thank you so much for listening to this episode of the podcast. I hope you are well and you've had a great bank holiday weekend, and I look forward to speaking to you again in 2 weeks' time. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.